Welcome back to the deep dive. Our mission here is, well, it's simple. We take the most tangled, complex, and frankly frustrating issues you run into in your daily life.
The ones that just seem impossible to solve.
Exactly. We find the deepest legal and economic analysis out there, and we try to deliver you the core, actionable insight.
And today's topic is a big one.
It really is. If you rent a home in a modern residential society, cooperative housing society, a condo, a really stringent HOA, you have almost certainly run into this specific friction point.
The shared amenities.
The shared amenities,
Yeah.
the pool, the gym, the much coveted clubhouse. The owner pays that mandatory monthly maintenance that's supposed to fund these facilities,
Hey.
yet the tenant, you, is often charged a separate or a much higher or just a seemingly arbitrary premium fee just to walk through the door.
It is at its heart a conflict. It's a conflict between the paper rights of ownership on one side and the practical rights of possession on the other.
That's a great way to put it.
The society, they look at the tenant as a secondary resident,
Mm-hmm.
a temporary guest, maybe.
Mm-hmm.
But the tenant sees themselves as having paid for full access. It's baked into their rent.
Absolutely. And the legal battle here is fought on really, really technical ground. So our goal today is to equip you with the precise language, the precise understanding, the legal hammer, if you will, to understand or, maybe even challenge these practices.
And we're going to go beyond just the general idea of fairness.
Way beyond. We are diving deep into some powerful legal doctrines that govern property rights. We're talking about concepts like unjust enrichment and the really crucial kind of complex idea of privity of estate.
Our source material for this deep dive, it's grounded in some exhaustive legal analysis. We've pulled from judicial precedents, things established by Supreme and High Courts,
That's the highest levels.
the highest levels, and we've meticulously examined the statutory frameworks that govern housing in this region. I'm talking about the Transfer of Property Act of 1882, the Real Estate Act, or RERA, and then all the various state-specific cooperative statutes.
This isn't just theory, then. This is the operational reality of how these disputes are handled right now.
Exactly. This analysis gives us the current operational legal reality.
Okay, let's unpack this. It's a huge body of law, so let's start by just setting the legal boundaries. What is the specific conflict we are analyzing today?
Okay. The core issue we're tackling is extremely specific, and it's important to get this right. The question is, can a residential society lawfully impose differential charges for accessing common area facilities, like a clubhouse or a gym on tenants, compared to property owners?
And here's the key part, right?
This is the absolute key. When these facilities are maintained through regular, mandatory maintenance contributions paid by the owner.
That distinction is so critical. If the upkeep of the pool is non-negotiable and it's baked into that monthly maintenance bill that the owner has to pay, that's where the legal tripwire is.
Precisely. And right off the bat, the initial legal finding is very strong. The brief answer from all of this analysis is that, generally,
No, they can't do it.
Generally, no. Such status-based discrimination is impermissible, and it's very vulnerable to a legal challenge.
Okay.
If the facility is funded by mandatory charges that the tenant, constructively pays for through their rent, then imposing additional or higher fees just based on their status as a tenant, well, it clashes fundamentally with established principles of property and contract law.
That sets a really powerful baseline for this entire conversation. But to really understand the why, we have to zero in on how these facilities get their money. Because as you said, the funding model dictates the legality of the charge.
It dictates everything. The analysis, it identifies 3 distinct structures for facility funding, and we really need to clearly isolate the one that's at the center of this legal firestorm.
Okay, walk us through those 3 structures, maybe. Maybe give us a clear analogy for each one.
Certainly. The first, and this is the most central one for our discussion, is the monthly maintenance charges model. This is that compulsory fixed fee that's assessed against all the unit owners.
The one we all know and love.
Right. It covers the core operating budget. So security, the lighting in common areas, lift upkeep, and crucially for us, the running costs of those common facilities, like the clubhouse.
Think of it as your all-inclusive utility bill for the whole community structure.
That's a perfect analogy.
Yeah.
It's the classic HOA or CHS structure where everyone pays. It doesn't matter if you ever step foot on the treadmill.
Got it. Okay, what's the second model?
The second model involves corpus fund contributions. Now, these are different. They're often large, one-time capital contributions that the owner makes when they first buy the property.
So a big lump sum at the beginning?
Exactly. And its purpose is primarily for major long-term repairs or replacement of the physical infrastructure itself. It's the capital investment in the building.
So it builds the clubhouse, but it doesn't run it.
Precisely. It typically does not cover the day-to-day operational costs like staffing or cleaning. Those fall under the first model, the monthly maintenance.
Okay, and the third funding structure.
That is the separate user fees for specific amenities model. This is genuinely pay-per-use, completely ring-fenced activities.
Ah, so like an a la carte menu.
Exactly. For example, if the society runs a professional coaching academy at the tennis court, or if you want to rent a specific banquet hall for a private wedding party, that is the optional a la carte service model.
So just to lock this down for everyone listening, this entire deep dive is dedicated to addressing fees for facilities that are funded by that compulsory fixed cost monthly maintenance charge. That's model number one.
That is the entire legal pivot point.
If the owner must pay for the clubhouse upkeep no matter what, then the tenant's right to use it is at its strongest.
It is. I mean, if the clubhouse were genuinely ring-fenced and operated purely on Model 3, say, it was run by a totally separate entity that charged membership fees completely disconnected from the mandatory maintenance.
Then it's a different story.
It's a very different story. The society's ability to charge differently increases significantly in that case. But the moment those facility costs are bundled into the general maintenance, which is compulsory, the legal standard shifts profoundly. And it shifts in favor of the tenant having equal rights.
Okay, so let's establish the legal foundation that governs these disputes. Societies often have this argument, right? They say, look, we're a private body, we're governed by our own bylaws. How does the law get past that argument?
It gets past it through the application of overriding public law principles. While a housing society is, technically a private entity established by contract and statute, the courts have consistently held that their actions cannot be arbitrary.
Right.
So we start with this fundamental principle of non-arbitrary action. This principle, it's derived from concepts like the constitutional right to equality, and it permeates contract and property law.
So the society's bylaws, they can't just be capricious or discriminatory. They have to have some kind of rational basis.
Precisely. If a society's action, like this differential charging, is found to be unreasonable or disproportionate or based purely on the status of the resident, owner versus tenant, it is immediately vulnerable to challenge.
So the rule of law still applies.
The rule of law requires reasonableness, even behind the private gates of the community.
Okay, now let's look at the foundational statutes that define the relationship between the two key players here. The owner, the lessor, and the tenant, the lessee.
We have to begin with the Transfer Property Act 1882, or TPA. This is the absolute bedrock legislation that defines property rights in this context. And we're interested specifically in Section 108.
Section 108, okay. And how does that section protect the tenant in this specific scenario?
Section 108, it stipulates that the tenant, during the term of their lease, is entitled to make use of the property as if they were the owner. It's subject only to the terms of the lease and, reasonable restrictions.
So they step into the owner's shoes for practical purposes.
In a way, yes. And this entitlement gives rise to what the law calls the implied covenant of quiet enjoyment. This is a critical term.
Quiet enjoyment. I think a lot of people assume that just means the landlord won't play loud music next door or something, but it's much more expansive than that, isn't it?
It is so much more robust. It ensures the tenant can enjoy the premises without substantial interference from the lessor or anyone acting on their behalf, which, by extension, very often includes the housing society.
And enjoyment of the premises is the key phrase there.
It is. Crucially, it isn't limited to the four walls of the flat. It includes access to all the common facilities that are considered appurtenant to the leased premises.
Okay, let's pause on that word. Appurtenant. What does it actually mean for a right to be appurtenant?
Think of it this way. An appurtenant right is something that legally and necessarily belongs to the property because it enhances that property's utility and its value. A common staircase is appurtenant.
Right, you need it to get to your apartment.
Exactly. A parking spot that's allocated to the unit is appurtenant. The lifts are appurtenant.
So follow me on this. If the owner paid a premium for their flat because it was in a building with a state-of-the-art clubhouse, then access to that clubhouse is a right that it runs with the land. It doesn't matter who's actually living there.
You got it exactly right. The value and the function of that leased unit are inextricably linked to the common areas. Without access to those common facilities, the unit's value is diminished. The TPA establishes the foundation that the right to use what makes the property valuable passes with the lease.
Okay, so that's the big overarching federal law. We also have the state-level statutes, like the cooperative statutes, things like the Maharashtra Ownership Flats Act, MOFA, for instance. How do they fit into this picture?
These statutes, they govern the internal management structure of the society. So they'll outline how owners become members, how maintenance is levied, how bylaws are created and passed.
But what's the problem with them?
The problem is they often contain what we call interpretive gaps when it comes to tenant rights. They're really focused on the owner-member relationship.
Ah, so they dictate the rules of the society, but also just fail to clearly define the status and the financial obligations of a non-member resident, like a tenant.
Precisely. While the model bylaws usually require tenants to comply with society rules, they very rarely explicitly authorize differential charging. And
Yeah.
this silence is what forces the courts to step back and apply the broader, more powerful property law principles we just talked about.
It's like the TPA.
The TPA, the principle of non-arbitrary action,
Hmm.
they use those to fill in that gap. The society can't use its own silence or its own internal rules to override fundamental lessee rights.
And what about RWA, the Real Estate Act from 2016? I mean, that primarily regulates the developer, not the society. Why does it inform tenant rights?
RWA's philosophical underpinning is what's crucial here. It enforces transparency and accountability in the housing sector, and it prohibits unfair practices.
So it sets a tone.
It sets a tone. While it mainly addresses developer-buyer issues, the overarching principles of non-discrimination and clear disclosure. They inform the court's interpretation of subsequent property disputes. If a society implements a charging structure that is opaque or unfairly discriminatory, RWA's ethos provides an additional layer of scrutiny. It pushes the legal interpretation toward ensuring equity for all residents.
Okay, that strong foundation leads us directly into the core legal mechanism. We've established that the tenant should have the right, but how does the law actually transfer the owner's right into the tenant's hands? This is the legal transfer mechanism, the listener's true aha moment.
We are now diving into the core doctrine of lease law. It's called the doctrine of privity of estate.
Okay, let's treat this doctrine like the baton in a relay race.
That is an excellent analogy. When an owner executes a lease, they don't just hand over a key, they're handing over a bundle of rights. The privity of estate dictates that for the duration of that lease, the tenant legally acquires the possessory rights and all the accompanying easements that are associated with that property.
So they don't become the owner, they don't get the title, but they do acquire the functional right to live there and to use all the associated benefits that come with it.
Exactly. We call this the transfer of beneficial interest. The owner, the lessor, they step back from the exclusive use of the property and its appurtenances.
And the tenant steps forward.
The tenant, the lessee, steps forward to occupy the owner's place, but only regarding the property's utility.
So if the owner has the right to use the common passages, the parking, the security services, and the clubhouse, that entire bundle of rights gets passed to the tenant. It runs with the land.
It runs with the land. It's subject only to the lease agreement and reasonable rules. The society cannot selectively honor the lease by allowing the tenant to use the flat, but then denying them the very amenities that make the flat valuable and desirable.
Especially not if the owner is still paying for those amenities through maintenance.
Especially then. The facility access is appurtenant. It enhances the utility of the residential unit, and the lease transfers that utility. It's that simple.
And now we connect that transfer of rights to the economic issue. This is the indivisibility principle, and it sounds like this is the reason why these differential charges really fall apart legally.
The indivisibility principle states that common area facilities maintained through mandatory monthly charges create an indivisible bundle of rights. You cannot separate the right to use the facility from the obligation to pay for its maintenance.
They're a package deal.
They are bundled together.
And the society is attempting to unbundle them, but only for tenants.
Which creates the economic double charging scenario. Let's just trace the flow of money, because that's where the injustice becomes so tangible.
Okay, walk us through the financial chain of events. Let's make it real.
Okay, step one. The property owner pays the mandatory maintenance fee. Let's say it's 10,000 rupees a month. And let's assume, for the sake of argument, that 2,000 of that is explicitly for the clubhouse operations staff, electricity, cleaning.
Okay, so the owner is out 10,000.
Step two. The owner charges the tenant rent. That rent is necessarily inflated by the fact that the property includes a 2,000 rupee per month facility benefit. The tenant pays the owner, and in doing so, effectively covers that maintenance cost.
The cost is passed on.
The cost is passed on. Now, step three, the violation. The society then turns around and charges the tenant an additional 500 or 1,000 rupee premium fee just to use the clubhouse that was already funded in Step 1 and constructively paid for in Step 2.
That is textbook double dipping. The money has already entered the system to fund that specific benefit.
It is the core violation of the principle of unjust enrichment. This is a legal doctrine that forbids one party from obtaining a benefit at the expense of another without a legal justification.
And here the society is enriching itself.
Yes, by charging twice for the exact same service. Once from the owner, through the maintenance, and then again from the tenant, through the premium fee. The tenant has already shouldered the economic burden through their rental payment.
I think this constructive payment idea is where a lot of owners and societies get confused. They'll argue, well, the tenant doesn't pay us the maintenance directly.
But the courts look past that. They look past the immediate transaction to the economic reality of the situation. The maintenance cost is factored into the rental calculation. It has to be.
Right. If it weren't, the owner would be losing money.
Of course. And think of it this way. If the society suddenly closed the clubhouse for a year, the owner would demand a reduction in their maintenance fees.
And in turn?
And in turn, the owner would have to reduce the rent because the property's value and thus the beneficial interest that was transferred to the tenant would be lower. The tenant is footing the bill, indirectly but demonstrably.
And this isn't a new idea. This is backed by judicial precedent, right? Are there specific cases that emphasize this point?
Yes, we have crucial judicial support. The precedent set in a case called Syndicate Bank v. Vijay Kumar, for example, established that tenants who are lawfully in possession cannot be denied essential services and facilities that are associated with the property.
So the minute you have a legal lease,
The moment lawful possession is granted via a lease, access to the pertinent facilities follows. Any denial or any kind of punitive pricing is considered interference with that lawful possession.
and what about that principle of non-arbitrary action? Is that also reinforced in case law?
Yes, a very famous case, Zoroastrian Cooperative Housing Society, Ltd. While it was focused on membership rights, it confirms that a society's internal rules must adhere to the test of reasonableness and rationality.
And discriminating based on status isn't rational.
If the society tries to discriminate based purely on the status of the occupant owner versus tenant, it is often found to lack that rational basis that the law requires.
Okay, so let's summarize the most common conflict scenario based on this powerful legal framework. This is scenario 1. Clubhouse maintenance is included in the mandatory monthly maintenance charges.
In this scenario, the legal position is pretty unequivocal. Differential charging based solely on ownership status is impermissible.
And the decisive rationale, the one sentence that every listener should memorize.
The facility is funded by an indivisible mandatory charge. The economic burden is transferred to the tenant via their rent. To impose an additional premium charge on the tenant is discrimination without a rational basis, and it violates the prohibition against unjust enrichment.
The society is collecting money for a service already paid for.
Exactly.
That is incredibly clear. And yet, societies are still doing this. They have justifications, however weak they might be. Let's pivot to Section 3 and start applying critical thinking to the most common rationales they use and show why they just don't hold up in a court of law.
Right. And we need to analyze these rationales not just by their stated intent, but by whether the fee they're charging is actually proportionate to a legitimate administrative cost,
Or if it's just a punishment.
or if it's just functioning as a punitive measure.
Okay, the first and probably the most easily defensible claim on the surface is the administrative burden argument. What's the core of their claim here?
Societies argue that managing tenants incurs genuine extra costs that owners do not. They'll cite the need for tenant verification, police reporting, frequent access card issuance because of high turnover,
Updating records.
updating society records, and just the time spent handling documentation and security formalities every single time a lease changes hands. They claim the premium charge is just cost recovery for this labor.
That sounds reasonable enough. I mean, if there's an administrative cost, shouldn't the person causing it, the tenant or the landlord, be the one to bear it?
They absolutely should. But the counter-argument is all about proportionality and timing. These administrative costs are typically minimal, and crucially, they are one-time costs. They're associated with the beginning of the lease.
Okay, so how does that translate financially? Let's break it down.
Let's use a hypothetical. An administrative background check might cost the society, say, 1,000 rupees in labor and fees. Issuing a new biometric access card might cost 300 rupees. So the total legitimate administrative cost might be 1,300, maybe 1,500 rupees.
A one-time cost of 1,500.
A one-time cost. And that cost can and should be recovered. It should be recovered through a reasonable one-time registration fee. That's scenario 3, which we'll get into later. But what societies often do instead is levy a recurring premium of, say, 500 rupees per month for the entire duration of the 12-month lease.
So that's 6,000 rupees for a 1,500 rupee cost.
Precisely. That large recurring fee is completely disproportionate. It cannot be justified purely by those small initial administrative costs.
And I suppose owners create admin costs too.
They do. Societies overlook that owners also generate administrative costs, transferring a title, getting approvals for major renovations, adding new family members to access lists. Singling out tenants for a recurring premium based on these minimal one-time costs lacks a rational proportional basis.
Okay, let's move to the second major justification, which relies more on semantics. This is the club membership distinction argument. The idea that owners are members of the society, but tenants are just users or guests.
This is what we call legal formalism. It's an attempt to use terminology to justify financial discrimination. The society frames the clubhouse as a private club that's reserved for its members, the owners.
And so tenants are just guests using the facilities as a courtesy, which justifies charging them more.
That's the argument. But didn't we establish earlier that if the facility is funded by mandatory maintenance, it can't really be a private optional club?
Right, the logic falls apart there.
Absolutely. This distinction just collapses when you look at the funding model. If the owner has no choice but to pay the mandatory charge, if they cannot opt out of funding the facility, then no genuine membership choice even exists. It's simply a communal service that's attached to the property.
And crucially, when the owner leases the flat, they also lease their beneficial interest in that mandatory service.
Correct. The owner can't retain the membership privilege while transferring the possession rights and the economic burden of that service to the tenant. The tenant's legal leasehold rights, which come from the TPA and the doctrine of privity of estate, they just override this semantic labeling of guest. The law recognizes the tenant as a lawful, temporary resident, not a visitor.
Okay, let's tackle the most punitive justification, the one that really involves social control. Using high fees for the deterrence of rental activity or to manage so-called transient population concerns.
This is where the legal analysis becomes quite forceful. Societies may claim they are trying to maintain a community character or discourage high turnover.
Suggesting that tenants are less invested.
Less invested, more likely to cause damage or disputes. They use the high fees to indirectly restrict the owner's lawful right to rent out their property.
This sounds an awful lot like thinly veiled discrimination.
It's often viewed as exactly that. It's status-based discrimination and illegal social engineering through financial punishment. The law protects an owner's right to rent their unit, and the courts are extremely skeptical of rules that indirectly impose a restriction based on the occupant's status.
Because it's based on a stereotype.
It operates on a stereotype, the generalization that all tenants are short-term, uninvested, or disruptive.
So how should societies address genuine concerns about behavior or turnover without resorting to these kinds of discriminatory fees?
Through non-discriminatory means that target behavior, not status, implement uniform rules and penalties for misuse that apply equally to all residents, owner, or tenant.
Makes sense.
If the concern is damage, the society can require a reasonable, refundable security deposit from all non-owner residents, not a recurring monthly access premium. If the concern is turnover, they can impose that one-time registration fee we discussed. Status-based pricing is punitive and highly likely to be struck down by a court.
And that takes us back to that crucial legal concept you mentioned earlier, the principle of proportionality. It's the metric the courts use to separate a legitimate charge from a punitive one.
The quantum, the sheer size of the differential charge, is the litmus test. If a society cannot demonstrate that the differential fee is rationally related to an actual, justifiable, and unique cost associated with the tenant, then the charge fails the test of proportionality.
So let's try to define the boundary here for the listener. What separates a fee that's maybe marginally defensible from one that's clearly punitive?
The analysis offers a pretty clear spectrum. A difference of, say, 50 to 100 rupees might be marginally defensible.
If they can prove it.
If and only if it represents minor, genuine administrative overhead that is slightly higher for tracking non-owners, and this must be justified on paper.
Okay, but what about a bigger fee?
A difference of 250 to 500 rupees, which often represents a 50% or greater premium over the owner's implied cost, that is almost impossible to justify purely on a cost recovery basis. This signals punitive intent.
So if the owner is paying the equivalent of, let's say, 1,000 rupees a month for clubhouse access through their maintenance, and the tenant is then forced to pay 1,500, that extra 500 is the vulnerability.
It is the smoking gun. A court will demand a detailed breakdown showing exactly where that extra 500 rupees is being spent. And if the society can only point to those minimal, one-time administrative costs, the charge is likely to be deemed arbitrary and therefore illegal.
And just to be clear, complete exclusion.
Complete exclusion, or setting fees so high that they function as exclusion, is almost certainly impermissible. It's a direct violation of the appurtenant rights that are transferred via the lease.
Okay, so we've established that differential charging is illegal when the facility is bundled into that mandatory maintenance, which is scenario 1. Let's now pivot to the exceptions and the safe harbor alternatives for societies.
Right, so we need to examine scenario 2, independent cost recovery. This is the narrow, very narrow avenue where differential charging may be permissible.
Okay, what are the near impossible conditions a society must meet to prove that this structure is legal?
They must prove that the facility is genuinely and completely ring-fenced. This means two things. First, absolutely no general maintenance fees from Model 1 can contribute to the facility's upkeep, its staffing, its utilities, or its repairs. None.
And the second thing?
Second, it must be run on a transparent cost recovery or user fee model. This often requires a facility to be treated almost as a separate legal entity within the society.
I would imagine that in most complex residential properties, separating utility costs, security staff time, and general maintenance labor completely, that's practically impossible.
It is extremely rare. And that's why scenario 1, where discrimination is illegal, is the norm.
And even if they manage it?
Even if the facility is perfectly ring-fenced, the legality of a differential charge is still heavily scrutinized. Any difference has to be minor, it has to be proportionate, and it must strictly reflect demonstrable, unique administrative costs associated with temporary users. The base usage fee for the tennis court, for example, must be the same for everyone.
Okay, so if a society wants to protect itself legally and address its genuine administrative needs, it really needs to move into scenario 3, the one-time registration or deposit. This is the safe harbor.
This measure is generally permissible because it shifts the financial obligation away from status-based pricing and towards genuine cost-based recovery. A society can legally charge a reasonable one-time fee or deposit.
And just to be clear, what are the acceptable costs that this fee can cover?
It has to cover tangible costs. These include the actual expense of producing and issuing physical items like access cards or setting up biometric registration. It can also cover the administrative overhead of mandatory police or background verification processing.
And what about a security deposit?
Most importantly, it can cover a security deposit, but only if it is refundable upon the tenant's satisfactory departure. This can cover potential damage to the common areas or fines for rule violations.
That makes a very clean separation. The cost of administration is borne once at the beginning, and the access to the facility, which is already funded by mandatory maintenance, is free of any recurring premium.
It's legally sound because the charge is linked to a transaction, the lease registration, not to the ongoing use of the appurtenant right itself.
Okay. Now, let's get into the consequences. For societies that choose to ignore these principles and continue imposing these high discriminatory differential charges, the risks are substantial.
The legal analysis advises societies very strongly to reassess their bylaws because the risk exposure is high. The most immediate threat is, of course, legal risks.
Lawsuits.
Affected tenants can and will initiate civil litigation. But the deeper threat is that the entire bylaw authorizing the charge can be challenged as being ultra-vires.
Which means beyond legal power. What does that mean in practical terms for a society?
It means the society's own actions, the resolution or the bylaw that they passed, are found to be beyond the legal authority granted to them by the state statutes, like MOFA or the TPA. It's because they violate fundamental property rights or principles of non-arbitrary action.
And if a bylaw is declared ultra-vires?
It is void from the very beginning.
And the greatest financial sting, which you hinted at, is the refund liability.
This is the risk that should keep society treasurers awake at night. If a court deems the charges discriminatory and illegal, The society could be ordered to refund all of those premium charges collected from every single affected tenant.
And not just going forward.
No, potentially spanning many years of collection. If a society has 500 units and 100 of them are rented out over a 5-year period, that liability can quickly become hundreds of thousands, if not millions, in recovered fees.
Wow. That is a massive retroactive financial consequence that just vastly outweighs the small monthly premium they were collecting.
Absolutely. And on top of that, societies face significant reputational risks. In major metropolitan areas, online reviews and community forums are tracking tenant-unfriendly communities.
I've seen those.
And this reputation can actually reduce property values over time. Discerning investors will seek easier-to-rent properties, and high-quality tenants will actively avoid the community. This undermines the very financial health the society claims it's trying to protect.
So the attempt to grab a few hundred extra rupees per month creates this substantial multi-year financial and legal risk.
It creates unnecessary friction, it increases internal disputes, and it invites the kind of legal scrutiny that most housing societies are generally ill-equipped to handle.
And to give our listener a bit of perspective here, this isn't just some localized problem arising from a specific statute. This legal trend of protecting tenants, it's evident worldwide. Let's look at the comparative perspectives.
The analysis shows a clear global movement toward ensuring non-discrimination in housing services. In the United States, for instance, the Fair Housing Act is strictly enforced, and state consumer protection laws scrutinize differential pricing very closely. They often require demonstrable justification for any difference in service cost.
What about somewhere like the United Kingdom or Australia?
In the United Kingdom, leasehold law dictates that service charges, which is what they call the funds for common area maintenance, must be reasonable and uniform for all residents receiving the service. Discrimination in service provision is actionable.
And Australia.
Similarly, Australia's strata title legislation ensures tenant access is protected, and the body corporate is generally forbidden from discriminating in the provision of services based on who holds the title to the property.
So the message is pretty unified across mature legal jurisdictions. Status-based financial discrimination in providing services that are funded by mandatory maintenance it's fundamentally flawed.
It really confirms that the legal principles we see in the TPA and the doctrine of unjust enrichment are just localized expressions of a much broader global principle of fairness in communal living arrangements.
So let's synthesize all of this into some practical advice. If societies need to address their legitimate concerns about administration, security, turnover, what are the recommended non-discriminatory alternatives they should be using?
The focus must shift entirely from status to cost recovery and behavior. First, societies must adopt a uniform user fee structure. If a facility requires separate charges, like booking a community hall, all residents, owners, and tenants alike must pay the same flat rates for those usage fees.
No discounts for owners, no premiums for tenants, equal treatment across the board.
Exactly. Secondly, they must limit tenant-specific fees to reasonable registration requirements. This means only a one-time cost-based administrative fee or a refundable deposit. This covers the background checks, the access card costs. It addresses the administrative burden without becoming punitive.
And for those persistent behavioral concerns.
Behavior-based restrictions. The society should invest its time in creating clear, enforceable rules and penalties for misuse, noise, or property damage. And these rules and penalties must be applied equally, regardless of the resident's ownership status. This ensures order and security without resorting to financial discrimination against a legal class of residents.
This analysis has provided an exceptionally sharp, very detailed, and evidence-based look at a conflict that generates just immense frustration in multi-unit properties.
The synthesis is powerful because it exposes the fallacy of the society's justification. It does that by tracing the actual money flow and the legal transfer of rights.
Right. So synthesis of key takeaways. The core vulnerability of any differential clubhouse charge lies in the fact that common facility access is not a privilege the owner can hold back. It is a fundamental, a pertinent right that is legally transferred to the tenant via the doctrine of privity of estate.
And because the tenant is constructively funding the maintenance of that facility through their rental payments, imposing any significant premium based purely on their status as a tenant constitutes unjust enrichment. It's discrimination without a rational basis, and it leaves the society open to massive refund liability.
Okay, before we wrap up, let's give the listener some concrete recommendations for action based on everything we've discussed from the source material.
Okay, for tenants and owners who are facing these discriminatory fees, the immediate action is documentation. Keep records of all the charges, all correspondence, and the society's specific bylaw regarding the fee.
Get it in writing.
Get it all in writing.
Yeah.
Second, formally request a written justification and a detailed cost breakdown for any differential charge. This forces the society to prove proportionality on paper. Third, review the lease agreement carefully to determine if the owner has already explicitly allocated facility fees.
And for the societies that might be listening in, how do they mitigate the significant risks that we've just discussed?
They must adopt uniform pricing immediately, right now. For all facilities funded by mandatory maintenance fees, they need to conduct a transparent accounting review to ensure they are not collecting the cost of the clubhouse twice.
And tenant-specific charges.
Any tenant-specific charge must be limited to a one-time, cost-justified administrative fee, and ideally it should be structured as a refundable deposit. Acting now minimizes future financial exposure.
The analysis we've been drawing from repeatedly noted that rental housing serves an essential social function. It represents a massive and necessary portion of urban housing stock. It really seems the legal system, by enforcing principles like the TPA and RWA's focus on fairness, is recognizing this socioeconomic reality.
It is. It's a gradual, but it's a decisive evolution. The law is moving to protect tenant rights to equal treatment, recognizing renters not as transient problems, but as essential residents who contribute to the community's overall well-being.
So, here is our final provocative thought for you to consider as you reflect on this deep dive. If legal frameworks continue to evolve to protect tenant rights, enforcing non-discriminatory access and ensuring that tenants are treated as equally valued, non-punishable residents, how might this broader recognition reshape the power dynamic within these residential communities and fundamentally redefine the very concept of community character in the coming years?
Will the financial distinction between a title holder and a resident eventually become irrelevant for enjoying the shared life of the society?
The implications for social equity and the future structure of property management are profound.
It suggests that community is defined by residency, not solely by ownership.
That's all the time we have for this deep dive. We trust this knowledge empowers you to understand and navigate these complex property disputes quickly and thoroughly. We'll see you next time.